Have session, Page and Morton versus Darius Nunley.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. It occurs we have both parties present. Paige Van Norden, plaintiff mother, and defendant father Darius Nunley. Good morning, both of you.
Good morning, sir.
This court scheduled this pretrial conference in order to move this matter forward and then to get an order entered regarding custody and parenting time. The two of you have conferred with Ms. Brower this morning from the front of the court. Ms. Brower has provided the court the following recommendation. If the court adopts the recommendation, it will become an order of the court. Your child is 7 months old. It's recommended the two of you share joint legal custody. Joint legal custody means that you must share equally and communicate regarding any important decision concerning the welfare of your child, like elective surgery, schooling, religious upbringing. If you cannot agree, then the court decides those matters. And hopefully two of you as parents know what's best for your child rather than having the court decide these matters. Joint legal just that. For example, mom, if the child goes to the emergency room with the doctor, you must notify dad, emergency room. Or if the child is going to the pediatrician for vaccinations, whatever, you need to inform dad in advance of those things.
Absolutely.
And then vice versa. If the child's with dad, you got to notify mom if there's an issue with the health of the child.
Yes, sir.
This recommendation also provides for parenting time. Specific parenting time as follows. Father shall have parenting time every Friday, 9:30 a.m. to Sunday at 9 p.m., as well as every Tuesday from 4 p.m. to 10 p.m. and every Wednesday, 4 p.m. to 10 p.m. Mother shall provide all transportation, pick-up and drop-offs. The two of you will share holidays as agreed. If you cannot agree, then the fallback is the front of the court holiday schedule. You can go online, get a copy of the Monroe front of the court holiday schedule, and that's what's going to apply if you cannot otherwise agree. The best schedule is one the two of you can work out together, whether it's Christmas Eve. So work together on those things. Communication is the key. Further, it's recommended with respect to child support that commencing April 1st to 2024. Mr. Nunley, father will pay child support about $10 per month. Ms. Broad, the minor child is receiving public assistance. Is that correct?
Yes.
Yes.
Okay. Now, custody, parenting time, child support, they're always subject to modification. As circumstances change in the future, as the child gets older and as your income change, those are all subject to modification. What we need to do is focus on what's best right now. And in terms of parenting time, joint legal custody, the court likes every case to begin with joint legal custody. The two parents should be able to raise this child together and make those important decisions together regarding the welfare of the child. Parenting time, obviously, it's subject to change. As the child gets older, the child's going to have own activities. Dad's work schedule could change, mom's work schedule could change. So parenting time is always subject to modification. We need to focus on what's best for your child right now. Perhaps we could put in here, Ms. Brower, that primary residence of the minor child shall be with the plaintiff mother. Because obviously the mother will have the majority of the time with the minor child, which is not unusual for a 7-month-old child. So we can put in their primary residence with the plaintiff mother. So we're going to add that one thing to this recommendation. Ms. Van Norden, do you understand the recommendation this morning?
Yes, I do.
Do you have any objection to the court adopting this recommendation?
No.
Mr. Nunley, do you understand the recommendation?
I do not, sir.
Okay, you don't understand it?
Yeah, can you just repeat it? I'm sorry if I missed it.
Okay, you didn't hear anything?
No, just the last part that you had said.
Okay, I'm not sure what last part. The recommendation of Ms. Brower? No, the last comment I said that that's appropriate since the child is majority with mom, that we simply note here that the primary residence of the child shall be with mother.
Okay.
So we're not, people get hung up on this title of physical custody. So we say primary residence with mom. Dad has parenting time every Friday, 9:30 a.m. to Sunday, 9 p.m. Every Tuesday, 4 to 10. Every Wednesday, 4 to 10. Mother will provide all transportation.
Right. And do I still have custody of her, though, is my question, I guess.
You have joint legal custody.
Okay. All right. Yes. Yes, yes. I'm okay.
Okay.
I understand.
And obviously, the court will adopt agreement if you as parents believe it's the best for the child. 10 o'clock seems late. What time does the child go to bed? We're waking up the child to transport. Is that, and if you both agree that's appropriate, then
yeah, she usually goes to sleep around that time. It starts to go to sleep, so that would actually 9 o'clock would be perfect.
Well, this says 4 to 10 on Tuesdays and Wednesdays.
Oh yeah, she said sorry. She said 10. Yes, you're right. You're right.
9 o'clock on Sundays. 9 o'clock on Sundays.
Yep.
All right. We'll start with you, Mr. Van Norden. Can you please state your name and current address for the record?
My name is Paige Van Norden.
You and Mr. Nunley brought into this world a minor child by the name of Salem, almost about 7 months old. Is that correct?
Yes, sir.
Okay. Do you believe this recommendation of joint legal custody, primary residence with you, and a specific parent for dad to be in best interest of your child at this point in time?
Yes, I do.
Okay. Obviously, if transportation becomes an issue, then obviously two of you just decide that. An issue you cannot decide between the two of you, then you can petition the court. The court would decide. But the reality is, the two of you know, as parents know what's best for the child. You don't want a stranger deciding these things.
Mm-hmm.
All right, Ms. Van Norden, do you have any questions for the court?
I do not know.
All right, Mr. Donnelly, can you please state your name and address for the record?
Yes, my name is
I wanted
Darius. To actually state that for the record on file is that when I got my court mail sent, it was sent to the incorrect address. And I didn't know about the court date until a little late. So if I didn't get that paper, I would have potentially not been able to show up and be present today. So I would like to have that address changed, please.
Okay. I want to repeat the address because we just used the address that Ms. Van Norden provided us. That's why we mailed it out. So I'm glad you got notice. Why don't you repeat the address once again?
And, yeah, I know I've resided here for almost 6-7 months now. So yeah, I know I've been here for a minute.
All right. Ms. Brower, were we able to capture Mr. Nunley's current address?
Yes, I did, Your Honor.
Does he need to come in and fill out a form with front of the court to update his address?
He does. We can mail him a form for him to complete and return.
Okay.
Okay,
You can mail it out with this order. Is that correct?
Yes, Your Honor.
Thank you for making things easy, Mr. Nunley, Mr. Brower.
Absolutely. I wanted to say though, I do live in a mobile home, so the unit number is 5. I just wanted to add that in there.
Okay, so the front of the court will mail you a copy of this order. They're also gonna mail you a form. You need to fill it out and sign it, verifying that's your mailing address. And if you either one of you move in the future, you need to notify the other party and the front of the court in writing.
Yep. That's why I wanted to make sure it was on the record now that you guys had the wrong address from the beginning.
Well, we got it from Miss Van Norden, so it wasn't us guys having your address. So I'm glad you updated that, Mr.
Yes, sir.
Nunley. Mr. Nunley, do you believe this agreement, this recommendation to be in the best interest of your child?
Yes, sir.
Are you asking the court to adopt it?
No.
Are you asking the court to approve this recommendation?
Yes.
All right. Do you have any questions for the court?
No, I don't.
All right. The court finds this agreement to be in the best interest of minor child based upon the agreement of the parties. The court will accordingly adopt the same. Thank you, Ms. Brower. And Ms. Brower, can you add like one sentence in the recommendation about primary possession, minor child, or primary residence with mom?
Yes, Your Honor.
Okay. All right. You both mailed a copy of this. Good job, mom and dad. Communication is the key. And your son will recognize in the future if there's
daughter, sorry.
Tension, your daughter, if there's tension. So make things good for each other and your daughter, please. And it's all about communication.
Yes, sir.
All right, so that will conclude this hearing. You both mailed a copy of this, and good luck to both of you. You can zoom out and have a good rest of the day.
Thank you so much.
All right. Thank you so much, sir, for your time.
You're welcome.
Appreciate it.
The court will also enter the uniform support order. Thank you, Ms. Brower, for your assistance.
You're welcome, Your Honor.
The record of this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Court is in receipt of what appears to be a proposed consent judgment of divorce, and both parties appear to be present. Mr. and Mrs. Scott, good morning.
Good morning.
The two of you have confirmed with Mr. Pratt in front of the court this morning. Mr. Pratt has provided the court with a uniform child support order, for which the two of you agreed to reserve child support. That issue needs to be addressed in the judgment. That's why you talked with Mr. Pratt this morning. So you'll both agree to support the children. Is that correct?
Correct.
That is correct.
And if there's any issues, either party can always petition this court for a child support order. And your children are not receiving public assistance at this time. Is that correct?
Correct.
Correct.
All right. Thank you, Mr. Pratt.
Thank you, Your Honor.
All right, Mr. Scott, can you, before we begin, you're separated in December of 2023, is that correct?
Correct.
Okay, there's a statutory 6-month waiting period in any divorce case in which there's a minor child or children, just to make sure there's no chance of reconciliation. The 6 months time frame begins to run the date the divorce complaint was filed. In this case, the divorce complaint was filed on December 29th by Mr. Scott. The 6 months expires June 30th, 2024. This court, however, does have the authority to waive that waiting period if you both would agree. And you both believe to be in the best of your children to simply finalize things sooner than later, finalize things today rather than after June 30th. So, Mr. Scott, are you asking the court to waive the waiting period under the judgment of divorce today?
Yes, sir.
Do you believe it to be in the best interest of your children to finalize things sooner than later so you can move forward?
Yes, sir.
Right. Same
Yes,
question
sir.
for you, Ms. Scott. Ms. Scott, same question for you. Are you asking the court to waive the balance of waiting period and the judgment of divorce today?
Yes, sir.
Do you believe that to be in the best interest of your children to finalize things today rather than later?
Yes, sir.
All right, the court will do so. Thank you. Is it true, Mr. Scott, you filed a complaint for divorce with this court on about December 29th, 2023?
Yes, sir, it is.
Is it further true that on the date you filed the complaint that you've been a resident that you've resided in Monroe County for at least 10 days in the state of Michigan at least 6 months?
Yes, sir.
Is it further true that you married Jillian Scott on December 22nd, 2017? You separated in December of 2023.
Yes, sir.
Is it true that there were 3 children born during your relationship with Miss Scott?
Two children born, one adopted, sir.
Okay. So, but the 3 of you, the 2 of you share 3 children.
Yes, sir. Yes, sir.
Okay. Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable chance of reconciliation?
Yes, sir. That's true.
And is it true that you've signed your name to this proposed judgment of divorce, approving the terms and conditions contained therein?
Yes, sir, it is.
All right. Thank you. Ms. Scott, could you please state your name and current address for the record?
Jillian
Thank you.
Krenz.
And Ms. Scott, did you hear the testimony this morning of your husband, Matthew?
Yes, I did, sir.
Was his testimony true and accurate to the best of your knowledge?
Yes, sir.
Are you currently pregnant?
No, sir.
And did you also sign your name to this proposed judgment, proving the terms and conditions contained therein?
Yes, sir.
I'm going to walk through this judgment with both of you. It's wonderful. The 2 of you are going to co-parent your 3 children. You're going to share joint legal and joint physical custody. Parenting time is equal. The 2 of you will work out a schedule. If there's an issue, you can always petition the court for a specific parenting time schedule. But this is the best schedule, but it requires effective communication. Obviously, children get older, they can have their own activities. So communication is truly the key. And it'll make a difference. Your children will thrive if they know mom and dad are on the same page and communicate for their best interests. Child support, again, that's been addressed. The court will note in the judgment of divorce that that's reserved, and I will put that word reserved in the judgment. I'll put my initials next to that term of reserved. You've agreed that neither party be awarded spousal support, and that be forever barred. You've already divided your personal property, so each will keep the personal property currently in your possession, free and clear of any claim on the part of the other, and pay any debt on that property. There are no joint debts, so each will pay any debts in their own name. Is that correct? There are no joint debts?
Correct.
That's correct.
All right. Each will keep their own automobile and pay any debt thereon, free and clear of any claim on the part of the other. There's no real estate to be divided, no pensions or retirement plans to be divided. And Ms. Scott, you're going to keep the last name Scott, correct?
Correct.
Okay. Finally, you've added a provision, other provision that says Jillian Scott is to remain on Matthew Scott's family health insurance plan until either Matthew Scott has a change of employment or Jillian Scott is able to obtain health insurance coverage through an employer or other means. I'm just letting you know, Mr. Scott may have no control over that. And generally, once Mr. Scott's employer becomes aware that there is a divorce, they're going to terminate the coverage for you, Ms. Scott. So usually it's at the end of the month. Again, so you got to be very careful, because if in fact, let's say that you have elective surgery next month, you want to make sure that they don't deny that claim. So this provision is sort of illusory. It's, you can't, I'm just warning you that you can't come back and You know, the court thinks it should be stricken because I don't want you coming back and asking Mr. Scott to be held in contempt because you have health insurance and he has no control over it. So of course, there's two things you can do. You can either purchase insurance through Cobra, COBRA, and then of course it's usually a high rate. That's the rate that Mr. Scott's employer would charge. You can continue with the same coverage. Otherwise, go into the marketplace and the Affordable Care Act and secure health insurance. You're obviously fine for the month of March, maybe even April. And again, you don't need to, I'm sure, Mr. Scott, who do you work for?
The City of Taylor Police Department.
Okay. Yeah. I mean, you can always make inquiry, but if they find out there's the divorce, they're not going to continue that coverage for Ms. Scott. So I don't know if you can quietly inquire in your HR department about that. You can inquire about what's the cost of Cobra. They can tell you offhand what's the cost of Cobra without telling them, that there's a divorce, but you want to sort of delicately ask some of those questions. Obviously, you want to make sure Ms. Scott has health insurance.
Right.
So what did the two of you want to do about that? Do you, again, I'm reluctant to keep the same language in here because Mr. Scott has no control over this. Ms. Scott, unless he agrees that he's going to pay for Cobra until you secure other coverage.
We've already talked about it. I don't want him to pay for Cobra. We were just hoping that his employer would allow me to stay on if we had that in the divorce decree. And that's what we agreed upon.
Right.
Okay. If you both understand the implications, I'll leave that language in here.
Yeah, I do.
Okay. So maybe it'll make a difference. It may not. They're not. This is between the two of you. It's not. Doesn't bind the City of Taylor. Just so you're aware.
Okay.
And maybe it'll carry some weight, and hopefully it will. So I'll leave that in there. Obviously, what we're talking about is all recorded. So if there's an issue down the road, Ms. Scott will not be able to come back and ask the court to hold Mr. Scott in contempt of court for not making this continue. So work together on this, especially if you have any. Do you have any elective surgery scheduled, planned?
No.
Okay. If so, I was going to say we could always hold up entering this judgment divorce for a month or two. But if in fact you're healthy, you have nothing scheduled, there's no reason to really delay this matter. All right. So with that having been addressed, both parties understand the implications. I'll leave that language in here. Mr. Scott, do you have any questions for the court?
No, sir.
Ms. Scott, do you have any questions for the court?
No, sir.
Well, the court applauds both of you for putting together this consent judgment, working through these issues together, and obviously continuing to raise these children together. It will make a difference. The little things in life are important. Mr. Scott, always make sure the kids get a Mother's Day card from mom on Mother's Day, and same with mom. Make sure they get dad of Father's Day and Father's Day. Those little things mean a lot to your children. They do. So, and always talk respectful about the other parent in the presence of the children. It makes a big difference to those children. There's nothing more harmful than one parent talking negatively about making disparaging remarks about the other parent. But it sounds like the two of you are have it together. So the court recognizes that and appreciates that. All right. Based upon the testimony that's been presented this morning, as well as complaint filed this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties being as hereby dissolved, and judgment shall enter, granting a divorce from bonds of matrimony. Court will sign the judgment this morning. You both mailed a copy of that. Good luck to both of you.
Thank you, sir.
You're welcome. You can zoom out. Have a good rest of the day and weekend.
You as well, sir.
You as well.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. It appears that we have both parties present. You are Gina, Old Team Georges. Is that correct, ma'am?
Yes, sir.
Sir, you are Ronald, Old Team Georges?
Yes, sir, Your Honor.
All right. Good afternoon, Mr. Walker. Have you had a chance to talk with the parties?
I did, Your Honor. I have scheduled a mediation with the parties for April 29th at 8:30 in the morning. It seems that the main issue at hand is debt.
I'm sorry, debt. Okay, unsecured debt. So April 28th at what time?
8:30 in the morning, Your Honor.
Okay. All right, to Mr. and Mrs. Olteen Georges, there'll be a Zoom mediation with Mr. Walker. Have you both exchanged copies of credit card debts? What if they're credit card debts? You both need to be in possession of those, so you both can agree what debts are owed and how much. So you should exchange that information in preparation for this mediation.
Yes, Your Honor. I came with all of those papers and I'll get them to her, sir.
Okay, Mr. Walker, would since Mr. George is here in the courthouse, would it be helpful if he dropped off a copy to your office this afternoon?
Yes, Your Honor, he can do that.
Okay.
Okay. Should he take that to the main window downstairs?
Yep, on the main floor, Mr. Olteen Georges said on the main floor at the front of the court office.
Yes, sir. I know where that's at. Thank you.
And tell him that they're to deliver those to Mr. Walker for his mediation. Mr. and Mrs. Olteen, George is Mr. Walker is a very experienced, accomplished mediator. He's going to help you find some middle ground. The best resolution is one in which you both participate. So the court will mail you each a notice. Miss Gina, you have confidential address. We can get that from the front of the court. We'll mail you a copy of this notice. Mr. Ronald, your address is 619.
Yes, Your Honor.
Okay, we'll mail both of you a notice to mediate with Mr. Walker on April 29th, 2024 at 8:30 a.m. and subsequently appear before this court for a continued pretrial conference. If we don't have a resolution, the court would schedule it for trial. Obviously, that is if this is marital debt, marital expenses, then obviously it's sort of divided according to respective incomes. But if in fact Ms. Gina took a trip to Las Vegas for $10,000, then that may be considered her own expense. So it all depends whether or not these are marital debts or not. So please exchange any credit card statement each of you have with the other. Is there any other issues? Do we have any real property that needs to be divided and pension benefits?
No, sir.
It's a pretty short
Your Honor.
marriage of one. You've been married with just 1 year and you separated in September. Have you already divided your personal property?
We're
Yes, sir.
divided good on all those things, Your Honor.
I'm sorry, sir.
We're divided good already on all those. It's just some debt we need to work out. Things that are in our joint names, a loan and a fifth wheel that we can sell, hopefully.
Okay. Okay. So that's the only issue is the debt. And yes, if there's an asset fifth wheel, liquidate it. But you both need to be involved in what you're going to accept. You can't give it away.
Yes, Your Honor.
So, so they text each other. I don't know. I heard Miss Gina said something about it. There's a PPO in place. Is that correct?
Yes, sir.
Does that prohibit contact?
Yes, sir.
Okay, so Mr. I don't have it in front of me. I was not aware of that. So Mr. George, can is he prohibited from even texting you?
No contact, it says.
Well, and then you got to look at the PPO. It's not that broad. It usually says don't come to your home, don't stalk you. But if it says do not text you or call you by phone, then that's different. So how does Mr. George's, for example, if he wants to sell the fifth wheel, how does he communicate that to you in terms of what he's proposing?
Mutual friends.
Okay. And who's that?
We decided to go through Dominic.
Okay. Do you both of you have Dominic's phone number? Know who he is?
No, he hasn't agreed to it yet. This is a big ordeal. I don't know if he's going to want to get that in depth. So the mediator is the best route.
All right. I was just hoping you could have some communication between now and this mediation date of April 29th. Exchange information. You should both be exchanging information. If some credit cards are in your name and one name, you need to exchange. So you both have a copy of those. So the court's suggesting put them in the mail then. I guess maybe write a letter. I don't know if that's prohibited. I don't have a PPO in front of me. Is Mr. George prohibited from even mailing you, ma'am?
I'll have to reread the PPO. Your Honor.
We were texting until November 13th. That was our last texting date.
Okay. Mr. George, does PPO prohibit you from texting her?
No, That's why we were watching movies, doing all kinds of things until
Okay.
November 13th.
All right. I don't know what happened November 13th, but Mr. George, if the PPO does not prohibit texting, then take a picture of some of these statements, text them to Miss George's, or put them in the mail so they can be prepared for mediation. And yes, you should probably get a value, make some inquiries of how much you can sell this fifth wheel for. Get rid of that debt at least. So
Yes,
do as
Your
much as
Honor.
you can to prepare for this mediation. All right. Anything? And Miss George, we sent you a proposed judgment. Do you have that? The form
Yes, sir.
judgment, 2-page. So keep that with you because you ultimately need to fill that out. If you have an agreement with Mr. Walker on April 28th, you need to fill that out, and both you need to then sign it. You can fill it out, sign it, bring it here to the courthouse, and then we can hold it. And Mr. George can come to the courthouse to sign it, so you don't need to have contact. Okay.
Thank you.
All right.
Yes.
So put in your calendar, April 28th, 8:30, and the court will mail you Mr. Walker's Zoom ID number.
That's 29th or 28th, Your Honor.
29th at 8:30.
Okay.
All right.
Thank you.
All right, that, unless, do either of you have any questions?
I don't, Your Honor.
Okay. All right, you both zoom out. Thank you, Mr. Walker.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome.
Court is now in session. A. Scott Breschneider versus Betty G. Magnac.
For the record, this matter is before the court for a review of parenting time. Subsequent to the parties having engaged in mediation with Mr. Pratt. Present for the Zoom hearing is Attorney Kimberly Kuhn representing the plaintiff father. Scott Breschneider. Mr. Breschneider is present with Ms. Kuhn. In addition, Attorney Shannon Lucas is present representing the defendant mother Betty Mandernack, and Ms. Mandernack is present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
The court has been informed by Mr. Pratt that the parties have reached their own agreement relative to continued parenting time. I don't know if there's any changes, but who would like to place the agreement on the record?
Your Honor, I believe the agreement is as follows, that the parties are going to start their week off parenting time for the summer at the end of the school year. We are going to see how the week off parenting time goes. We have a review scheduled, or on mediation for parenting time expansion review scheduled August 15th at 1:30 with Ms. LaPrade. We're going to see how things go and hopefully continue with the expansion. I would ask that we set this matter over for a pretrial if the court would have availability on its calendar on Thursday. So if we could have a pretrial following mediation, that would be appreciated.
Certainly, the court can do that. Ms. Lucas, is that a correct statement of your client's agreement today?
Yes, it is, Your Honor. Thank you.
Very well. Is it necessary to voir dire the parties? Ms. Kuhn or Ms. Lucas, do you want the parties sworn?
Not at all.
I don't believe so.
All right, who will prepare the order?
I will, Judge.
All right, thank you. And yes, Ms. Kuhn, you can put in there that the parties can appear before the court for review subsequent to the April 15th, 1:30 mediation with Ms. LaPrade.
Yep,
I'm sorry,
Review
August
August?
15th.
Yep,
Yes, I'm
August.
sorry, I misspoke.
That's fine, Judge. Yep, I sure will.
Oh,
The
wonderful.
order will
Court
just-
states-
I'm
sorry,
sorry,
go ahead,
Your
Ms.
Honor. I
Lucas.
had one question. The current parenting time order is just going to continue. Is that right? So we're going to keep, okay. Thank you.
Correct.
We're simply addressing that will continue, but for the summertime, it'll be week on, week off.
Correct.
Okay.
Correct. The week on, week off is in the current order, Your Honor. So yes, the parties will, until the end of the school year, the current parenting time order with regard to the one midweek overnight and the alternating weekends from Friday to Monday will continue. And then at the end of the school year, the parties will then do their week on, week off summer parenting time.
Very well. And the court notes that the exchange are on Sundays at 7 o'clock. So essentially, we're just continuing the order of January 23rd, but agreeing to review this again in August 15th at 1:30, correct?
Correct.
Wonderful. All right. Thank you, Ms. Kuhn and Ms. Lucas and Ms. LaPrade as well. That will conclude this review. Thank you. Have a good rest of the day.
Thank you. Have a good weekend.
Alicia Stanfield, is that correct?
Yes.
Okay, sir, Tyler Stanfield, President Audio.
Yes, that is correct.
Okay, and you've been married 9 years, but you've been separated for about 8.5 years. You separated about 5 months after your marriage. Is that correct?
Yes.
Yes.
Okay, is there anything at issue? Do you own any joint property or any joint debts, anything that needs to be divided by this court?
No.
Nothing at the moment.
Well, it's rather than at the moment, is there any property that needs to be divided? Do you have any joint debts or joint property?
Oh, I apologize. No.
Okay, so the court mailed to Alicia a proposed form of judgment back on February 5, over a month ago, about 6 weeks ago, and it's a 2-page form of judgment. You fill in the blanks, and then you need to sign that, Ms. Stanfield, date it. Then you need to get Mr. Stanfield to approve it. And you have, in fact, filled that out. Is that correct? And you signed it?
Yes.
Then you mailed a copy of that
Yes,
to Mr. Stanfield. Mr. Stanfield, you just recently received it, and you have also signed it, bottom of page 2, and dated it. Is that correct?
That is correct.
And you have mailed it back to the court or to Ms. Stanfield?
I have mailed it back to the return address to Miss Stanfield.
All right. And Ms. Stanfield, you still resign. So when you get that, Ms. Stanfield, you need to bring it down to the courthouse. There's a drop box outside the courthouse. If it's on a weekend, put an envelope, put Judge Braunlich. If it's during the business hours, during the week, you can bring it up here to the Judge Braunlich's office on the 4th floor. The court will then sign it, and you both be mailed a true copy. All right, so in anticipation of that, the court's going to take some brief testimony this afternoon, so you don't need to come back to court. And Ms. Stanfield, is it true that you filed a complaint for divorce with this court on about December 15th, 2023?
Yes.
Is it further true that on the date you filed the complaint, you had been a resident of the County of Monroe for at least 10 days and the state of Michigan at least 6 months?
I have been what, sorry?
Is it on the date you filed this divorce complaint, December 15th, 2023, had you lived in the County of Monroe for at least 10 days and the state of Michigan at least 6 months?
Yes.
Is it further true that you married Tyler Stanfield on October 25, 2014? You separated in March of 2015?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there is no reasonable chance of reconciliation?
Yes.
Were there any children born or adopted during your marriage?
We had one daughter, but neither of us are the guardian anymore.
I'm sorry, what happened to your daughter?
My mother's the guardian now. She stays with my mom.
Okay, were your parental rights terminated?
Yeah. Both of them.
Okay. Okay. Are you currently pregnant?
No.
So other than your daughter, there's been no children born to you during the term of your marriage. I'm talking about from this October 2014 to March of 2024. No other children, correct?
Correct.
All right. Do you have any questions for the court, Ms. Stanfield?
No.
Mr. Stanfield, could you please state your name and current address for the record?
My name is Tyler 5 Echo 3 Golf 2.
Thank you. Mr. Stanfield, did you hear the testimony of your wife, Alicia, this afternoon?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes.
And again, you've approved a proposed judgment sent to you by Alicia, approving the terms and conditions contained therein. Is that correct?
Correct.
Okay, so presumably the terms of that judgment is spousal support is not awarded. That's forever barred. Each will keep their own personal property. There are no joint debts. Each will pay debts in their own names. There's no real estate to be divided. Each will keep their own retirement benefits, free and clear of any claim on the part of the other. And finally, Ms. Stanfield, you can keep the name Stanfield. Is that correct?
That is correct.
Ms. Stanfield?
Yes.
Okay. Do either of you have any questions for the court?
No.
Ms. Stanfield, do you have any questions for the court?
No.
Okay, one last question. Ms. Stanfield, are you still receiving public assistance?
Yeah, I get food stamps.
Okay. Mr. Stanfield, are you on public assistance?
No.
Okay. The reason the court's going to ask is because there's a filing fee in the amount of $175 due to the Monroe County Clerk. And Ms. Stanfield, if she's the public assistance, that was waived by the clerk, but the taxpayer should have to pay that. So the court will order you, Mr. Stanfield, to pay the $175 filing fee to the Monroe County Clerk.
Understood. Is that in the United States currency or Canadian currency, just to clarify?
will be in U.S. currency. And what I can do is when that judgment comes, I'm going to add a sentence in there that you should pay that filing fee. And I'll put my initials in that judgment. So that's be part of the court order. And I'll give you as much time you need to pay that, Mr. Stanfield. Probably the easiest way for you, since you're not local, is we can give you a phone number. You call into the Monroe County Clerk and pay that with a credit card.
That I can happily do. I can have that paid.
They will not take personal checks, either cash or a credit card with the phone. They're going to charge, I think, 3% fee for a credit card, but that's obviously easiest. Unless you have family here locally that can come in and pay in cash. But if you got a piece of paper and a pen, we'll give you the phone number for the Monroe County Clerk. It's a $175 fine fee. You tell them it's a Stanfield divorce, give them the case number. They will then mail you a receipt, the $175. Do you have a piece of paper and a pen?
Yes, you can proceed when I'm ready.
Okay, it's 734-240-7044.
And is there an hours of operation for this number, or is it 24/7?
It's from 8 to 5, and they close from 12 to 1 for lunch.
And is that for Eastern Standard Time?
Eastern Daylight Time, yes.
Perfect, thank you.
So I'm going to put in the judgment date which you pay that. Can you you need until the end of April to pay that? Can you pay it by the end of March, Mr. Stanfield?
I can pay it actually on April 15th.
Tax day?
Yes, I can pay it on that day, yes.
Okay, so I'm going to put in the judgment. You pay that on April 15th. If for some reason you cannot, then call the court. And I will give you additional time. Just don't blow it off. You blow it off, that's when bench warrants issue, and you don't want that to happen.
Understood.
Okay, so you call that number on April 15th. Do you need a couple more days? That's a Monday.
Nope, that's perfectly acceptable for time. Is it okay if I also call in prior to that date if I can?
Absolutely.
Perfect.
So just
then yeah, it would just be April 15th at the latest.
Yep. Yeah, I'll put in the judgment. You'll pay $175 on or before April 15th, 2024, and pay that by credit card. And that's the easiest way. They're going to charge, I think, 3% fee. But you just tell them they'll ask your Monroe County Clerk. Tell them you want to pay a divorce complaint filing fee, $175. Stanfield divorce case, and give them your case number. You got your case number there, correct?
The case number, yes, I do have it here. Correct.
Yeah. All right, file number. All right. Ms. Stanfield, when you receive that judgment, please bring it in timely so that you can finally get divorced after all these years.
Yep.
Don't sit on it. And hopefully you can receive that real soon. Bring it down, either put it in the mail or drive down to court. And then once it's signed, the court will mail that out to each of you. Do either of you have any other questions for the court?
No.
Nothing at this time.
All right, based upon the testimony that's been presented this afternoon, as well as the plain file of this case, court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There is no reasonable chance of reconciliation. According upon receipt of the consent judgment approved by the parties, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter, granting a divorce from bonds of matrimony. All right, that will conclude. Everybody can both zoom out. Have a good rest of the day. And that will conclude this matter. Good luck to both of you. For the record, this matter is before the court for pretrial conference. It is being conducted via Zoom. Because we have Attorney Christopher Gajewski present for defendant Christopher Ryapel. Is it pronounced Ryapel?
Yes.
All right, Mr. Gajewski, good afternoon. And also we have the plaintiff Cassandra Ryapel present. We have an 8-year marriage. How long have the parties been separated, or are they still living together? Mr. Gajewski?
They've been separated for about 3 months now.
Court would like to complete a pretrial statement. I'm informed that you've talked with Mr. Walker from front of the court, and everyone is available to mediate with Mr. Walker on May 8th at 1:30 via Zoom. Is that correct?
That is correct, Your Honor.
The court will mail out that in writing, as well as Mr. Walker's Zoom ID number. And the court will also schedule a continued pretrial conference immediately following that mediation on the May 8th, 1:30. Mr. Ryapel, it's Mr. Walker's a certified, very experienced mediator. He's it's not binding. It's just an attempt to try to get the two of you together to facilitate your own resolution, which is by far the better solution rather than this court deciding these matters. So I'm going to send both of you a copy of this pretrial statement. In terms of the issues, I'm gonna start with you, Mr. Grajewski. Is there real estate that needs to be addressed and divided?
To my knowledge, there is no real estate that needs to be divided.
Okay. Is there significant unsecured debt like credit card debt needs to be divided?
Nothing significant to my knowledge based on the information I've been provided by my client.
Okay, so what about personal property division? Household furnishings and effects possibly?
There is personal property that needs to be divided, Your Honor.
Okay. Things have been quiet. Is custody printing time, is that an issue?
Yes.
Okay. And the parties have been separate. No one's filed a motion to develop mark custody and parenting time. 8-year marriage, spousal support presumably is not an issue. Would you agree, Ms. Rypel, that there's no real property to be divided and no significant credit card debt to be divided?
Yes.
Ms. Cassandra, would you agree those are the primary issues as custody parenting time?
There's no debt to be divided, but there is property.
Right. Is there any real estate?
Yes.
Oh, okay. Mr. Krajewski obviously was not aware of that. Is it the home you live in or cabin up north or what?
It's our camper up north.
Okay. Do you own the lot at which it's situated?
We don't. We pay rent on the lot. It is.
Okay. That's personal property. Mobile home, campers, personal property. No real estate, correct?
Right.
All right. Okay, that makes it much easier. So there's it's not a mobile, it's just a camper. Is that correct?
Correct.
Okay. All right. And obviously, if is there a debt owed on that camper, or is it owned free and clear?
I believe there's still a little bit more debt owed on that.
Okay.
That's my understanding as well.
All right. So if you can't decide who's going to get the camper, the best thing to do is maybe liquidate, sell the camper, pay off the debt, then you can divide the proceeds. Just an option, or that's something you need to both agree upon.
Okay.
All right. So, Ms. Rypel, you are available on May 8th at 1:30. Is that correct?
Yes, sir.
Okay. All right. So the court will mail out notice. I'm just identifying the issues for the court's edification and benefit. We'll provide you with Mr. Walker's Zoom ID number, and after that mediation, you appear before this court, and we'll go from there. If hopefully you can reach your own agreement. There's no reason why you can't exchange. You should exchange financial information between now and then. Mr. Krajewski, can you send to Ms. Rypel a verified financial affidavit for her to complete?
I will, Your Honor, and just for edification purposes, I was just retained today. I have pleadings already sent out in the mail for my appearance and other appropriate stuff, and I will provide Ms. Rypel the domestic relations verified financial information form so we can exchange those in the very near future.
Very well. We'll get your address out of the bar directory. So, Ms. Rypel, this is a mandatory form that you need to complete. It's just where you need to sign it from a notary. It's a verified financial information document. You need to complete that and mail that back to Mr. Krajewski. He'll likewise to send you one that's completed and signed by your husband.
Okay.
So there's full disclosure of assets and debts, any credit card debts and so forth. But in any event, obviously, whatever the two of you are doing in terms of parenting time, obviously is working. So no one's been running to court, which is good. There's enough challenges in life. Hopefully, you're able to communicate regarding Cameron's best interests. Anything further, Ms. Rypel? First of all, do you have any other questions for the court?
No, sir. Not at this time.
Right, Mr. Krajewski, anything further?
Nothing further at this time, Your Honor.
Okay, all right. That'll conclude this pre-trial conference. We'll see you everyone then after the May 8th mediation with Mr. Walker. All right, you can all zoom out. Have a good rest of the day.
Thank you.
Thank you, everyone. Take care.